In the Justice Court of Lafayette County, Mississippi. Lafayette County, prosecution versus Matthew Reardon, the defendant. This is the defendant's third motion for dismissal. Comes now before this court, Matthew Reardon, once again your defendant, and respectfully requests that this court grant him a clean dismissal for the following new complaints alleged. Number 1, trespassing. Number 2, family disturbance. Number 3, harassing phone calls. The complainant on the above-mentioned charges has had a long documented history of making false allegations against the defendant. Defendant alleges as intentional tampering with ongoing legal matters, as well as defendant refusing in principle to pay the $50 drop fee on an additional retaliatory harassing phone calls allegation that was made by the complainant in February 2020. After she bonded out of jail for the charge of filing a false report of rape for a staged attempt to frame the defendant for rape in November of 2018. Defendant vehemently denies all allegations made once again and states that it is his full intention to prove that not only did the complainant once again continue on with her pattern of asserting false and frivolous accusations, defendant made public the evidence, which should be considered exculpatory evidence of the arrival, interaction, and departure to Miss Crowder's property based on the recording. Miss Crowder is heard attempting to provoke defendant by contumaciously violating a standing child visitation order by denying the defendant his minor child on Father's Day weekend, doubling as defendant's normal weekend to have his child anyways, and the pickup and drop-off place for the child had become Miss Crowder's house, something that she had requested on numerous occasions. Therefore, due to the property being the common pickup and drop-off spot for the minor child, and based upon the fact that defendant promptly left after Miss Crowder maliciously said she was going to call the sheriff's department if he didn't leave, therefore, the criminal charge of trespassing would be an unfitting and undue charge for property that has no trespassing signs posted, and in a case where a common interest such as a minor child exists, in absence of any protective or restraining order. For the charge of family disturbance, defendant states the audio and video evidence demonstrates he went to the property of Miss Crowder with good intent to get and see his daughter, which would be a common expectation for most fathers on Father's Day. Miss Crowder's mother answered the knock at the door and went to get Miss Crowder before returning to another room in the house. Defendant's minor child was asleep or unaware her father was outside to see her, which left only the defendant and Miss Crowder in somewhat closer proximity. The way defendant responded was completely provoked by Miss Crowder denying visitation, communication, and even eyesight on his daughter. The complainant should be well informed by now that in order to find a party guilty for family disturbance, the conduct must be proven to be malicious, and this simply was not the case. Defendant states Lafayette County fails at meeting the burden of proof on proving based on newly released exculpatory evidence of the interaction and time span on the property. Defendant believes based on everything that Miss Crowder once again acted with malice intent in order to provoke or stage a series of events that bring the defendant before this court. This becomes even clearer to see when assessing the DCPS records to date on defendant's minor child, LER. It is in fact the perspective of the defendant that it was the complainant's actions that demonstrate malicious behavior and that she chose to prevent all access by defendant to his minor child after preventing access to the minor child for over 1 year based on lies. In essence, the complainant is trying her best to criminalize a family court matter, meanwhile justifying her continued use of a victim's assistance attorney by the name of Christy McCoy at no cost to frivolously overcrowd and back up the docket of this court after the defendant asserted allegations of fraud, misappropriation of grant money, as well as collusion that are incumbent of being examined and tried in a different setting and venue. For the charge of making harassing phone calls, defendant would either have that bound over for trial, in which a simple production of phone records would instantly prove, or defendant would request that this court, through a order to show cause, order the accuser to produce phone records and any evidence corresponding to this mysterious phone call before trial, or in the alternative, to dismiss the final complaint as moot and frivolous. Respectfully submitted this 4th day of August 2021. Matt Reardon, the Oxford Outlaw.
Hey, I was wanted to see Lydia.
Okay, I need to get Lydia to see you, okay?
I was here to see Lydia. You also, the last text you told me I could see her here.
Fine, man.
Really?
So,
It's my weekend with her. It's Father's Day also.
my weekend.
No, Father's Day is tomorrow.
Right.
Father's Day weekend, this was my weekend. Yes, it was, because 2 weeks ago,
Have you submitted your new address?
I don't have to give you
Yes,
jack
you do.
shit.
Yes, you do.
No, I
Have you
don't.
sub-
Oh,
If you don't leave, I'm calling the sheriff.
fuck off.
That's fine. I have all of it on camera.
So do I. I got it all recorded as well. You.
Yahoo.
Sheriff,
Okay, now? Yep. Okay, down.
bye.